think we had a little technical difficulty there, and I'm not sure how much of what we were doing you were able to catch. Hopefully you're still with us, but we were talking about Medicaid eligibility numbers, assets of $15,450, income of $859 per month for home care. Of course, if you're in a nursing home, you get $50 per month as your allowance. For married couples, both at home, the income allowance is $1,267. If one spouse enters a nursing home, the other is at home, the spouse at home gets $3,160.50. And the asset allowances, Frank, for couples at home, $22,800. And for couples with one in the nursing home, one at home, it's a minimum of $74,820 up to a maximum of $126,420 based upon 50% of the couple's total assets. So we're talking about Medicaid Asset Protection Trusts, again, a contract between a trustee, a grantor who transfers their assets in, and beneficiaries who are going to be recipients of that trust. So once the assets are in the Medicaid Asset Protection Trust, and it is an irrevocable trust, those assets are also then exempt for Medicaid purposes, provided it's structured properly. But not all assets have to go into the trust. Frank, you want to walk through the exempt assets?
Sure.
That people can maintain.
So if you're one individual, you can have up to $15,450 in your bank account, or total combined cash value of all your assets put together. So we do leave people with some amount of money when they're on Medicaid. We just reduce it below that $15,450 number. Your home, as long as you or your spouse lives in it, or a disabled child or a blind person, your house technically is exempt. There's other planning reasons why we put it in trust. But technically, if you or your spouse typically resides in a home, the home is exempt. You're allowed to have a car regardless of value. You're allowed to prepay your burial and funeral services. So that's one thing we always want to check with people, is just to make sure if you have prepaid for those services, to make sure it's an irrevocable arrangement. If it's not, the county will kindly ask you to change that. If you have business assets or other kind of property that's income producing, those as assets are exempt. The income is not. If you have a very small amount of life insurance, meaning total combined face value for all the policies you have, less than $1,500, the cash value of those is exempt. And this is probably one of the most important ones that we talk to clients about, Lou, and that's your retirement accounts. As long as they're in periodic payment status, which occurs automatically when you hit 70 and a half under current rules, then the body of those retirement accounts are exempt as well.
So when you're doing Medicaid planning, whether it be for home health care or nursing home care, you have to know the rules with regard to the eligibility levels, the exempt assets, what can people keep, and what do we want to protect. And when we look at the assets over and above exempt levels, and in some cases, we want to put the home into the trust for long-term protection. And other assets like businesses or income-producing property, we want to put into the trust for long-term protection. But there are certain things that stay outside the trust, including that minimal life insurance value, the IRA in periodic payment status, and as Frank said, that can be a major asset. So you could have an IRA, and that's 401k, 403b, any type of qualified retirement plan. You could have an amount of 500,000, a million, any number there. And if it is in periodic payment status, the income off that account has to be dealt with and is income. But the principal of that account is exempt already. So we do not put those into the trust. So in this case, we're going to put certain things into our Medicaid Asset Protection Trust, which we refer to affectionately as a MAPT, the acronym Medicaid Asset Protection Trust. And Frank, why don't we start with the first slide here of the trust scheme, which is clients transferring assets in and then receiving income back.
Sure. So I think that's one of the, I don't want to say surprises, but it's one of the good features of our trust, in that once assets are put inside the trust, and I want to take just a minute just to explain that just a little bit. So I always say the legal field, we don't do a great job of using terms the correct way or the easiest way all the time. So when we say you put something into the trust, really what we mean is that you've taken an asset, whether it's a bank account, your life insurance policy, your brokerage account, and the titling of that account has changed from you or your spouse or whomever as individuals to your trust, naming your trustee as trustee of your trust. Mm-hmm. So when we say put something in trust, we're just saying you've changed the titling on that asset. So we put assets into the trust, and then if any asset that we put in the trust makes income, so if it's a brokerage account, it starts making interest, dividends. If you have a rental property in there and you're taking rental income in, anything that makes income typically from within the trust is going to be able to be paid out to the grantor or the Medicaid applicant in this case as countable income for them, which we can save using a pooled trust, which we've mentioned before in other webinars.
Which we'll cover at the end in our example.
Sure.
So when we look at the Medicaid Asset Protection Trust and we look at asset transfers, we call this trust funding. And it's extremely important because you can have, and we've had clients that have done the trust and we walk them through the trust funding and they say, oh, we can do this on our own. And then 5 years later, they come back and the kids come in and they say, well, mom and dad did this trust, so they're fully protected, right? And if the assets were fully transferred in, the answer is yes. But in the event that the assets are not retitled properly or not retitled into the name of the trust does no good. So trust funding is absolutely critical. As important as having a trust is making sure each and every one of your assets is titled properly. If you have real estate, we prepare the deeds for our clients transferring real estate into the trust. If you have a business that's a corporation, we'll put the corporate stock into the trust, and we will provide our clients with explicit instructions on how to go to the bank, go to their broker, their life insurance agent, their annuity salesman, and work with each particular type of asset to make sure that the transfer into the trust is appropriate and the funding is complete. And we may want to mention, Frank, at this point, the difference when we do this, when we fund these trusts, the difference between home care and nursing home care.
Sure. So what Lou's alluding to with that is the 5-year look back. So if we're talking about putting a home care plan in place, we can design a trust, put everything we need to inside the trust, and then we have almost immediate Medicaid eligibility as of the first of the following month. If we want to talk about doing nursing home planning, however, because of the 5-year look back, the trust and any asset inside the trust has to be inside the trust for at least 5 years previous to when you apply for Medicaid. If you haven't made the 5 years, we typically take an analysis of what was done, when it was done, what the value of it is, and we go from there to determine whether we have to continue to ride out the 5 years, if we have to pull the trust back, or whatever it is that we have to do to make the situation work for the client at that point.
And you may be thinking to yourself, as our clients do, okay, this is an irrevocable trust. You're going to see in just a moment, or you see there, that I cannot get principal back from the trust. So that is one of the other features that is required in order for this particular trust to not be countable for Medicaid purposes. Irrevocable and no principal. So the assets themselves cannot be given back to the grantor. So a lot of clients ask, Frank, what happens if I do this and a year from now I need a nursing home? Because I'm still facing the 5-year look back. And the first thing to remember is you're eligible for home health care, community-based Medicaid, immediately upon the funding of the trust. So community-based benefits can be accessed right away, but nursing home benefits would have the 5-year look-back period applicable to them. And if someone does enter a nursing home before the full period of the trust has run, that 5-year look-back period, there are several things that come up that can be done. Want to walk through a couple of them, Frank?
Sure. So one is there's the private pay option, which we don't love, but sometimes it just makes more sense to do that. So if you did your trust 4 years and 10 months ago, it might be simpler just to private pay the remaining 2 months to get through the penalty period. But of course, to do that, you have to have cash and liquidity available to make those 2 months of payments. And hopefully we can figure that out.
And remember, you have an IRA, which can stay outside the trust. So it's beneficial to use the IRA to pay through that remaining look-back period, whether you last a year, 3 years, 4 years. If you have an IRA, that asset can be utilized to private pay till you get to the end of the tunnel and you reach Medicaid eligibility. That's beneficial in two ways. One, it keeps the assets inside the trust fully protected, but when you use an IRA, it's going to generate income that's taxable income. So what you can do from a tax planning perspective is use that IRA to pay the nursing home bill, which becomes a medical expense deduction. So we actually target retirement funds, 401ks and IRAs, as a source of payment for long-term care expenses, including home health care and nursing home care. If you have to pay privately, those are the best assets to use because you get an offsetting compensating deduction where you can wash the income tax on those assets. So 5-year look back, we have the ability to use outside assets. We're going to put in our home, bank accounts, stocks, bonds, annuities, life insurance, businesses, real estate. Those are all appropriate trust funded assets. And then we look at what clients want in terms of retained control. Because with an irrevocable trust, if I'm not getting benefit, then I have to be pretty comfortable that the people I'm working with, my trustees, are going to be doing the right things, and that my beneficiaries, if assets do come out of the trust early, and they can be distributed to the beneficiaries during my lifetime, are also going to be doing the right things. So part of the security that we build into the trust is that the client, the grantor who's putting assets in, can always change trustees. So if they appoint one child, what do they tell them if they're not doing the right thing?
They're fired.
You're fired. So that's something that parents can do, not a pleasant thing. And that's leverage, but the next bullet is even more leverage. And that is, if I'm a trustee, what does being a trustee mean? It means I'm doing work. And if I get fired, that means I don't have to do the work. But if I'm named as a beneficiary, that means that someday or now I'm going to get money from the trust. I'm going to get a share of the balance of the trust assets. Well, if I can be removed as beneficiary, that is significant leverage because I don't want to come off as beneficiary if I can help it. So I'm going to do the right thing during the grantor's lifetimes. Those are two essential features of the trust that build confidence in the grantor that I can still control what happens to this trust, even if it's irrevocable. And the ultimate tool, if you have the consent of the beneficiaries, is next. And that is, what if you want to pull the money back, Frank?
You can revoke the trust as long as you have the consent of all the beneficiaries and the grantors. So even though it goes against kind of common sense when you think of just the terminology used here, even though it's an irrevocable trust, you can revoke it. So under the worst of scenarios, let's say we did a trust and a year later there's a disaster and someone needs to go to a nursing home. We could revoke the trust, put all the assets back into the grantor's name just as if nothing had happened. And then we can use one of our other strategies like a promissory note or figuring out if there's a disabled child or something like that to further protect and save as much of the assets as we can, even if a nursing home is needed immediately.
And we did cover the nursing home eligibility scenario in our last webinar. And you can find those past webinars on Medicaid home care, Medicaid nursing home care, managed long-term care on our website at pierrolaw.com. And you can go and go to, I believe, the events tab. And if you go to Pierro Law events, you'll find all of our prior events and the webinars that we've done to date. And this webinar will be up there as well if you want to tell some friends and they're interested in seeing how Medicaid Asset Protection Trust is constructed. But if you look at these control features, and I can change trustees, I can change beneficiaries, and if I get the consent of those beneficiaries under New York law, and again, we're talking New York State specific here with regard to the trusts. Under New York law, a state's powers and trusts law, section 7-1.9, you can break an irrevocable trust with the consent of beneficiaries. So we can actually pull the assets back if we need to. And again, we're going to keep a certain amount of cash, bank accounts, our retirement funds outside the trust so that we never have to tinker with the trust. Even if we need money, we'll have it outside the trust. Or if we need money from the trust, how do we get that out?
Grantor calls the trustee or one of the trustees, if there are several acting at once, and they write a check from the trust to one of the lifetime beneficiaries, which is typically children, doesn't have to be. As long as it's not one of the grantors, they can get money out. And then once that person has the funds, they can then either use it for whatever expense is needed to be paid, or they can turn around and hand it back to the grantor. But that's not really the best case, use of the funds if they're already on Medicaid, because we got to watch how many assets they have in their name.
And that is permissible, not required. So the trustee has the discretion to distribute funds to lifetime beneficiaries, being mostly, in most cases, the children or other relatives or friends. And there's no compulsion on behalf of those recipients to do anything with that money, including use it back for the grantor's purposes. But if you have the right people in the right places, that technique can in fact work. So the advantages of the trust, like the revocable trust, it avoids probate, which in today's society, in today's world, probate courts are growing ever more burdened. We have single probate judges in most counties. Every will, every estate that is not going through a trust or with some specific beneficiary on the asset has to go through probate. We can distribute assets outright or in further trust to the beneficiaries. And again, many times, instead of having the trust simply break when the original grantors pass, it stays in trust for the children or other beneficiaries. We can hire and fire our trustees. We have access to the income within the trust, and the other beneficiaries have access to the assets within the trust. With the consent of all beneficiaries under New York law, this trust can actually be revoked. And for Medicaid purposes in the community, we can qualify immediately. You may ask, what are the tax consequences of a Medicaid Asset Protection Trust? And they're extremely favorable. The children don't have any liability or tax consequences. That's a frequent question. The grantors, the people setting up the trust, are going to continue to pay the income tax and, in fact, receive the income if and when they desire to get it. And with regard to the real estate, the one asset that is critical is the home, because the home has several tax advantages. Number one, most people have a STAR exemption if they're seniors, or a veterans exemption. That stays if it's in the trust. If you sell the house while the grantors are alive in the trust, it receives the same exclusion from capital gains tax under Section 121 of the Internal Revenue Code. So up to $250,000 for an individual, $500,000 for a married couple, can be excluded from capital gain on the sale of a residence from the trust. And when the grantors pass, when the assets pass downstream to the other beneficiaries, the children, etc., they get a full step up in basis on stocks, businesses, real estate, any assets that have appreciation. That appreciation will wash out and they'll get a full step up in basis. So from a tax perspective, the trust is much more favorable and powerful than outright gifts, and preserves many of the tax benefits that the grantors have. So Frank, with our last 5 minutes, let's go through a quick case study. And we have Rachel Brooks, age 84. Rachel is a widow. She was hospitalized. She had a fall. She's in rehab, and a lot of our clients come to us in this particular situation. She's going through the hospital, may or may not know whether she was admitted or put on observation status, is now in rehab, is looking at the days she may have Medicare coverage for rehabilitation. That Medicare coverage is going to be terminated at some point. And now we have to look at, if she does come home, can she get Medicaid? She does have some memory loss. She has some disorientation, possible mini strokes, but she is still verbal, probably has capacity, and her daughter lives nearby and can help when she can. She needs 10 hours a day of personal care. Her income is about $23.45 per month. These are her assets: a home, IRA, checking, and a brokerage account of $250,000. When can she be eligible for Medicaid?
So if it's today, so if it's June 10th, if we get our ducks in a row, we move our stuff around, we get our trust drafted, we move everything properly, we can apply as of July 1st, just because as of June 1st, she wasn't eligible due to basically that brokerage account being in her name.
And this is one of the myths that's out there. People think that the 5-year look back applies to all Medicaid programs. It does not. It only applies to nursing home Medicaid, not to community-based Medicaid. So the planning can be done in June and Medicaid eligibility established for July. So how do we get her Medicaid eligible for assets?
So we put in her home, not really for eligibility purposes, but to start the clock ticking on it, help avoid probate, do all good things that come along with the trust. But really what we do is we figure out we have to move that brokerage account because that's way over her $15,000 limit. And then if there are other bills, expenses, maybe some burial planning that can be done with the $25,000, we may have to move some cash, possibly. We'll just have to see how that goes. The IRA stays with her, just like we talked about.
And you mentioned earlier, so why don't we touch on it, the pooled trust and how that factors in from an income perspective?
Sure. So once we get the assets handled, we also have to look at income because as a single person, she can have $879 of income. As you can see, her Social Security and pension leave quite a bit more than that she brings in every month. So we want to be able to save as much of that as we can. So we create a pooled income trust, and she sends everything above that 879 number. So that's 1483 to the pooled trust. They establish an account, and it can be used for her benefit, and she stays on Medicaid.
So now Rachel can apply for Medicaid. What counts? The $15,450 left outside the trust. The IRA is exempt. She also has that in her name, that $75,000 that she can use at any time, but it's exempt for Medicaid purposes. Her income of $879 stays with her. The rest goes into the pool trust, and she would be Medicaid eligible with protected assets and protected income as of July 1st. In New York, we're able to do this for clients and get them benefits under the Medicaid program. It does not happen in every state this way. It is a state-specific program. So for Rachel, then we would go and we would apply for Medicaid, go through the MLTC program or the Nursing Home Transition and Diversion Waiver Program. We would use, in some cases, consumer-directed assistance program where you can hire your own aides. But in any event, for all of those, we would need an evaluation and assessment, and there are going to be some time lags. The MLTC time clock, we have to get a Maximus assessment, the conflict-free assessment first, and then the MLTC assessment. So what we're advising clients right now is to go through the MLTC process. It's about 4 months before you will have services available in the home to get all the approvals. So even if we apply on July 2nd, we're going to have roughly 4-month lag time to get the services started. For people who can't wait, who don't have other resources or people who can take care of them, there is a program called the Immediate Needs Program. We're starting to use that more and more frequently. More counties are seeing it, and that allows a determination by the county, and the time frame there is 12 days as opposed to 4 months. So last month's Medicaid Monday covered MLTC and the Immediate Needs Program in more detail. Today's program covered the Medicaid Asset Protection Trust. Other programs covered the home care program and the nursing home program and eligibility for each of those. And if you haven't seen those, please log on again to pierrolaw.com events. And next Medicaid Monday will be July 8th, and we'll be discussing in detail how the pooled trust works, how do you establish it, what are the details, how do you navigate that and get the income back to use to sustain yourself in the community if you're a person with a disability or a senior who needs Medicaid community benefits. So thank you for joining us today. If you'd like to meet with either Frank or myself or both, you can click to request a free consultation. You'll see the arrow there. Please do so. We'd love to see you. And remember, pierrolaw.com. We will take your comments at info@pierrolaw.com. If you have questions or comments, we'd love to hear from you. And thank you. Hope you can join us next week or next month on July 8th for our next Medicaid Monday.